Hello, good afternoon, everyone. Thank you for joining us today again in this Let's Inform You webinar, basically about the legal effects on after the 1st of January 2021. Today we've got experts and people from an association, Brexpats in Spain, who've been helping the expat community big time. On one hand, I've got Richard Hill. Hello, Richard.
Hi, nice to see you again, Ignacio.
We've got John Keel helping the Brexpat in Spain as well. Hello, John.
Hi, Ignacio. Nice to see you again, and thanks for having us.
We've got an expert on international law, and today he's going to tell us a lot about immigration. Hello, Pedro.
Hello, Ignacio. Good afternoon.
And we will have later on, they will join in today, Manuel Samper from Customs Agency, who he's being overwhelmed with a lot of questions about taxations and all other issues. Right, I'm going to pass over to Richard today. We've got on the right-hand side a lot of questions. Juanfran is going to just put them onto us, and we're going to try to be quick and specific as much as we can, because here we could try to cover general topics, and if later on they need to speak to any of us, we will happily answer to them. We're being very busy these days about with the situation of the immigration and what's the way forward. Some consulates are being in the lockdown, and you cannot even apply for an appointment, which we'll talk about this on the immigration side. And we're going to discuss with you all the questions about immigration, taxes, buying a property, or any legal issues. I'm going to pass over to Richard from Brexpat in Spain. Over to you, Richard.
Thank you, Ignacio, and hello to everybody. And I'm very pleased to be here again for the second of these Let's Inform You webinars. We had to split it because there were so many questions from the last one. There really isn't much that I can tell you that is new. There are a lot of questions, and I think that's going to go on for a while. And today I hope to talk to Pedro about some immigration issues that you've been raising with us, and also about pensions. We need to discuss that, and customs. They seem to be the prime issues. However, I am very much aware of questions being raised by parents in Spain with children who are trapped in the UK at the moment. And hopefully we will get time to discuss that today. Thank you, Ignacio, and we'll do what we can to answer the questions.
Thank you, Richard. John, would you like to add anything else, or shall we go straight into questions?
I think if we go straight into the questions, it would be a good opportunity for that right now, so we can get through as many as possible.
Right, we've got here on the right-hand side, Alexander Can. He's asking how much of a bank balance would be required now for a married couple to apply for residencia, based on the fact that they are not working and not in receipt of state or private pension. Also, one is an Irish passport holder and her husband is UK passport holder. They generally own a UK property, mortgage-free, that provides monthly rent. I think Pedro probably could start with what he might recommend. We've got one European and one non-European, Pedro. Over to you.
Okay, let me try to understand the question. Is one of the spouses is Irish and the other one is British? Is that correct, Ignacio?
Yes, correct. Yes.
Well, in that question, of course, the European Union citizenship by the Irish will be the first step, very straightforward, in order to obtain the residency. The proof is regarding which kind of a bank balance. I think this was asked at the beginning. Needs to be shown as an individual is 9,000 euros. I mean, it's like you have 9,000 euros a year in order to use a proof of spending in Spain, 9,000 euros. And of course, the British passport will be able to be attached into this residencia by the Irish, and will have to be shown by a couple, by a marriage, 12,000 euros. So at the beginning is application by the residencia by the European Union citizen, residencia de comunitario, and then will be attached this British citizen into this European Union citizenship as Irish, in order to obtain that. In the first one, in the first application is 9,000 euros, in the second one would be 12,000 euros maximum. Sorry, minimum, okay. minimum to obtain. It doesn't matter if it's, I mean, they have a property with mortgage or not, but it is extremely important that whenever they become resident, and we always repeat this again and again, whenever they become residents, they are attracted to the Spanish tax system. They have to declare and pay taxes in Spain. And this is what I was going to say, if they own a property or other kind of assets over the value over 50,000 euros, they need to inform tax office just an informative declaration, just to inform them that I own a property in UK and I rent it, which will be included in the income tax declaration, tax return in Spain. So that's important. So residencia is a must at the beginning, it is the entry door in order to start living in Spain, but always linked into taxes.
Yeah, that's very good, Pedro. Actually, you brought a point here, which I recommend people, not only when they start organizing themselves doing the residencia thing, trying to do tax planning, because there is a double taxation treaty that is still in place, nothing to do with Brexit, it will carry on. And actually it was 1977 signed between the countries. And my recommendation is to always do it at the same time, the tax planning and the immigration. And then if you decide to buy a property or rent, you could do it in between. Okay, as Pedro said, the 720 is a form, a worldwide assets declaration from January to March. And if you have above 50,000 euros on 3 categories: 1, bank account; 2, shares, bonds; and 3, property at the purchase value, you must declare it. And you will not have to declare it again if nothing changed, but if you donate, cancel the product, sale, you'll have to report it again. And then very important for people to know, in Spain, income tax return works from April until June. Okay, so this is 2 things, as Pedro said, that they're important. There is still double taxation treaty, and I'm sure, Pedro, there will be some cases where they will have the residencia, but they could prove they are non-taxable in Spain. But that's very specific.
For example, exactly, a civil separate pension. But at the end in Spain, as you know, we need to declare the worldwide income, even though it's exempt in some ways, sometimes. But regarding this couple, I'm not sure if they say they get a pension or not. If they get a pension and they are tax deducted, there is, of course, you need to prepare a form in order to inform tax office in Spain, to inform tax office in UK, in order to avoid being tax deducted, to receive most of the pension or all the pension gross, in order to be paying taxes in Spain. I mean, you have mentioned this double taxation treaty in Spain and UK, and this is how it works, really, in order to pay and declare taxes in one country and not in both countries, in order to avoid to payment, of course.
But I'm sure, Pedro, and I've seen with the accountancy department recently that some people, and here is one thing that Richard, through the webinars we went through, some people had the fear of residencia and the tax. But there is some people, but it needs very specific advice on here, that even though you have the residencia, according to the double taxation treaty, there is a way that you could still be tax resident in the UK, but only on the specific scenarios that is given in the double taxation treaty. There is some people working from Spain, but the link to the employer in the UK. So there are specific cases that even though you have residencia, you could still use it to pay taxes in the home country and to pay the rest here. But again, this is not just the normal thing. Is a specific, but happy to talk if that comes. Let's go back to questions. Hello, I intend applying for residency and buying a property in Valencia. would I be allowed to rent out part of the property? My daughter will be joint owner of any property. She also wants to work. Should she apply for a work visa and then apply for residency when actually working in Spain? Actually, quite important question, isn't it, Pedro? Is about work visa, which is very difficult, isn't it? It is very difficult, the work visa probably. So over to you, Pedro.
That's right. Well, first thing, it's equally that you don't need to be resident in Spain or non-resident. I mean, you buy a property. It's different. It doesn't matter if you are resident or non-resident. In this case, I think it says that is wants to apply for residency and then buy a property in Valencia, which is a fantastic city to buy and invest. It's a really, really spectacular city. I like it. I love it. And I mean, you apply for residency, buy a property in Valencia, and I think the question was to rent the property. Obviously, perfect, no problem. Of course, all the income that you get from the rent, you will have to declare it as a tax declaration because you are a resident, or even if you were not resident, exactly the same. You also have to pay taxes in Spain as non-resident. But let's put this example that is being asked. What if needs to be rent part of the property? I think was the question. Well, if it's part of the property is long-term or temporary term, no problem. It's a contract. It's, well, perfect on civil contract, perfect. But if this is going to be added to an internet platform where it shows and rents the property, let's say Airbnb or Booking, then it needs a specific license to do that. And that's important in order to run out, it's like a business on renting. In this case, it needs to be brought into a platform and for some specific days, and in order to book this kind of room or area to be rented, this needs to have a special license. And I agree with you, Ignacio, what you say about if in order to apply for the work visa, of course, it has some more difficulties, but why not to try, and why not to, of course, to check previously the situation. Yeah.
I think actually we've been handling recently a very similar case. Normally, I think it applies to young families who are willing to come over to Spain and then apply for work visa. Actually, it's a very hard. I've been just discussing this with our team. And we are recommending first, if you've got the funds to prove, to come as a non-resident visa, which you are not allowed to work. And from here, after the year being legal resident, swap it into a work visa from here, from Spain. Okay, we do not recommend it necessarily to do it over there because of the complexity. It's not a straightforward visa, and you will need to prove and convinced that kind of job is unique, and that's why you need to apply for that visa, you know. And actually now on these circumstances, having unemployment, it will not be very easy. Okay, Richard. Yes.
I'm being a bit pedantic here, but it's a question we're being asked, and maybe you and Pedro could clarify the position for people. It says in that question, I intend applying for residencia and buying a property in Valencia. Would your recommendation be apply for residencia and then get your property, or buy your property and then get residencia?
It's a good question. Actually, applying for the non-lucrative visa is not linked to having a rental contract, neither having a purchase contract. Okay, so we'll like to discuss with that person whether their priority is residencia. As Pedro said in the other webinar, I don't know if Pedro wants to add, some people prefer to come over here. I wouldn't even worry about the renting, you don't need it. Or it will be nice because they will need to provide to the Spanish consulate an address where they're gonna live. So they need an address where they're gonna live. But probably buying a property, if you're gonna regret if you didn't get the visa, I will probably recommend to start now with the visa and then make an offer, or just kind of a soft contract. Okay, I don't know if Pedro wants to add something.
Yeah, I mean, second question is, we're talking about non-lucrative visa. it is not a requirement to invest in a property. In order to, it is not. It is always a good link for the visa chiefs in order to see that you have a place to live, to sleep, a place to live. Either you need to show that, or you need to show a rental contract. But for the non-lucrative visa, it's a must to show sufficient money to live in Spain. There are some minimums, and we can enter on that minimums. And this is what you need to do, to have access to money in order to be able to live in Spain without working. That's a must. Apart from that, insurance, criminal records, and all this. But it is not compulsory to buy a property. If it helps, well, it helps that you have a place and you can show that you have a place to live in Spain, but it's not compulsory.
Right. Okay, let's move on because we have so many questions here in the panel. Hi there. I have a question. There's been some comments on expat forums referencing possible tax payments when transporting furniture from the UK to Spain as part of a relocation. Is there any truth in this? I don't think Manuel did join us yet, but I think, Richard, we should leave this to Manuel, which I'm pretty sure he's having a lot of issues on customs about the duties and the tax. And I know he mentioned about removals, that everything is costing more because they need to pay an extra tax. Okay, so we will just leave this for him. We've got Michael Williams. And he's asking, when applying for non-lucrative visa, what is accepted as proof of wealth? Could it be a lump sum, or does it need to be a monthly income? How long must the wealth be shown in a bank account before it will be considered as proof of wealth? I don't know, Pedro, if you want me or you want to go with that one? Yeah.
Well, I mean, what I said before, I mean, it's a must. I mean, you need to show non-lucrative visa is really a visa for. It was focused. It was created really many years ago for retiring people. So it is just to show that you have enough money to live in Spain for the period of time that you are allowed to be resident in Spain, and so you need to show that amount of money, and you have access to that money. It's not accepted that you have some money, but you don't have access to that money to show it. And at the end is the Spanish government needs to have a guarantee that you will have access to that money, not to need to work in Spain. So this is a visa for not working. It's not allowed to work. So regarding the lump sum or income, of course, if you were one or the other one is another. As much as you show that you have some, for example, monthly income, or you have a lump sum of money, they say, I have, for example, 100,000 euros based in a place in Spain or outside of Spain, or some income from some pensions, perfect. It doesn't matter if it's one. At the end, you need to show that you have access and you are going to have some money in order to live during that year. Okay, the minimum is always a principal who applies for the non-lucrative visa, and I'm going to show exactly I'll show you which is the amounts. As year 2021, we are talking about per person. The principal who applies for that is 7,908.60 times 4, which is around let's say around 32,000 euros. And if it's some family member, then will be around, I would say around 6,778. So we are talking about mostly roughly around 38,000 euros if it's a couple, for example, are married. Okay, so if the question, I don't know if it's answered, is just regarding a lump sum will be enough with income, or with an income will be in case that you have that money, sufficient money to live in Spain, you have to show that. And it is a subjective criteria by a visa chief in the Spanish consulate, and it needs to be shown perfectly that you guarantee that you're going to have money to live in Spain.
Yeah, thank you, Pedro. We've been having a lot of questions about this situation because, Pedro, the people wants to come and move on and buy a property. But sometimes it's catch-22 because what I was talking to some clients, if you just spend the money and you don't have the money, you only have a pension, probably you're not going to match with the requirements. So I will be very cautious, and I will ask people to not be tied to a budget on this balance in the account. If, for example, if the average is 30, 35, be very comfortable. I know probably it's best first to start with renting and looking around. I wouldn't like people buying and leaving themselves with no money, because they need to think, is 1 year visa permit, then you need to renew another 2, which is double, and then you need another 2 as well. Okay, and then you have 5, and on the other 5 there is no need to prove that funds, but you need to be bearing all these things in mind. And if people are buying a property and they're tight, I find that is going to be a problem for them. So I'm advising them to be comfortable and have funds, as Pedro said, with easy access. Okay, right, let's go back to the question. I think we did answer to Michael. Let's go with Anthony Oswin. A question: if a TIE application is rejected by immigration because the extra information has not been submitted yet, can you appeal because of the COVID restriction, and approximately how much would it cost for the appeal fees? Well, I think it's easy here to answer. You've got one option to appeal before the immigration office, or you've got within the month to appeal in our area. It will be Alicante court, but it will be another court. How much would it cost the appeal? Well, it depends whether it's before the extranjería office or if it's through the courts. And depending on complexity, I wouldn't recommend probably to go straight to submit before the same extranjería office, because probably they're going to say basically the same. We will recommend you to go through the courts. The problem with the courts, you need a barrister, a court runner, and it could cost you all these kind of things, about 2,000 euros probably approx, or depending on complexity, you know, because depending on the hourly rates of every single law firm. Okay, I don't know if Pedro, Richard, yes?
One of the specific bits of that question was, can you appeal because of the COVID restrictions?
Oh, that's
now,
right.
To our knowledge, you can't.
To be honest here, Richard, if they do before the extranjería, I don't think they will even accept it. The only way I could even say, depending on people, is try through your lawyer or through the lawyer that you would like to represent you, try to consider whether you had major force, any way to prove it, if you could ever prove it. But if you're applying for residencia, technically you should have been here in Spain. So if you are in a different country, you will have to prove why you were in a different country, and so on, so on. So there is a possibility to appeal, but very hard to prove that, I don't know, you left for Christmas or who knows, okay? But it's a good point. Now, let's go back to another one. I don't know if Pedro wants to go with Mike Hubban. I have an Irish and UK passport. My wife has a UK passport. We have booked to stay in Gran Canaria from early November 21 to the end of the 4th of 22nd, about 175 days. We don't intend to work in Gran Canaria. I'm retired and receive, amongst other income, a UK state pension. We have other assets. Right, we are all aware that the Schengen area countries only permit a UK passport holder to stay for up to 90 days within a period of 180 days. This stipulation, which many countries turn a blind eye to pre-Brexit, is now, I gather, being rigorously enforced. Spain is stamping all UK passports on entry to its territories. Malefactors who overstay the 90 days can be fined, deported, etc. I read what I think is the relevant material, and the path seems for me to register at the local town hall and police station after entry in the 11th. I understand it will be 11th of the, I don't know if he says November of the 21.
It is.
It is. by way of my EU citizenship. I can also include Manosi, I don't know who he refers, on the registration as a dependent of the EU citizen. But what I need is clear guidance from company that specialize. Right. I don't know if Richard pretty much understood what he needs, but
frankly, I think he needs advice of an immigration company. It's as simple as that.
Yeah, I think it's more about.
Yeah, this is complicated because of the mixture of Irish and British passports and dependencies. I wouldn't want to answer this one. Maybe Pedro.
Pedro, would you like to go on with this one? Probably, well, as Richard said, Irish passport will make things very straightforward. And as a family member, the other one, because he has Irish and UK passport, and his wife has a UK passport. So I think it's very similar, Pedro, to the one that you probably answered already.
Yeah. I understood well, because I didn't understand this about the beginning of the 175 days. Well, I mean, the rules is clear. I mean, of course, I mean, if it stays more than 90 days between these 180 days is clear. But he's got an Irish passport, as you said.
Yes.
Well,
I think it's easy for him, isn't it?
The answer is probably the same as we said at the beginning. Let's apply residency with the Irish passport. But do they want to be resident? This is my question. I'm not sure if they say that or not.
Well, if they don't want to be resident, they don't have a problem.
Wording is like they want to come and go out and then come and go out. I'm not sure, but well, let's put it, if they wanted to be resident, it would be like with the Irish passport, citizenship or European Union citizenship, show that he's got 9,000 euros, and whenever get residency, adding the marriage, the couple, and they need to show both of them together 12,000 euros.
But then they don't want to be resident, Pedro. They're swallows. They're just out here.
It doesn't look like, because I mean, with the wording about 107, well, I mean, not being resident, I mean, there are really two options: to be resident or not resident. No resident. The rules right now for the Schengen area is that being people fined or deported. I haven't seen it. I still haven't seen it right now in Spain. I don't know, Richard, if you have heard anything about right now about that. I haven't seen it. I haven't heard that. I don't think it's happening. But well, that's really the situation when they apply for residency.
Yeah.
In Spain and
I will add, Pedro, I will add probably the Irish passport will allow you to come and stay longer. Obviously, if you're going to stay more than 3 months, he should apply for residencia. And the wife with a UK passport, the problem is she only has the permit to stay 3 months. The problem is she will have to apply for an extension. It's very messy because you stay for 3 months, but once you move here, you'll have to apply for an extension to stay here legally, because the Irish passport will allow you to stay.
The Irish passport.
So the Irish passport, you will stay. You don't have to have residencia. And the other one needs a tourist visa with an option to extend it, and it needs a permit. So it's a hard situation that I might recommend to find another solution to this, if possible. As Richard said, probably that is better to discuss it, making a lot of questions and other alternatives to see whether that might suit them, because the other option they've got is to have the residencia, both the British have the family member residencia, and then make sure they stay less, trying to be non-resident, non-taxable in Spain. So it's a very, very specific situation that you need to be very precise. I've got Manuel here. Hello, Manuel. I cannot hear you, I think.
Hello, now.
All right.
Hello, good afternoon.
Hola, Manuel.
Hola, buenas tardes.
Right, Manuel, we've got one question here from Michael Lendrum. He's saying, Manuel is a specialist on the customs agency, private agency. He's got his office in Alicante, and he will leave you his emails, as everybody else will do now, in case you have need to make consultations specific with him. Manuel, we've got Michael here, Lendrum, asking that there's been some comments on Expat Forum referring possible tax payments when transporting furniture from the UK to Spain. as part of a relocation. Is there any truth in this, Manuel?
Yes, sure. Now we have a custom paperwork to do for relocation or for any transfer of goods. It doesn't matter if our goods of an individual person, non-commercial goods. They are under custom process and they are under duty payment. But we have the possibility to apply for a tax exemption with some conditions. The conditions custom here is requiring to leave the custom duty and don't pay them is they are requiring to give to customs a relation of the goods. You must make a relation of the goods you are carrying. You must demonstrate them, show them that you have been living at the UK more than 12 months before your moving, your relocation. There is it's not clear which document you must give customs to show that, because usually for other countries they ask about a document called baja consular in Spanish. Is the when you made the application in your country of origin, stating that you are not living there anymore. But British consulates are not issuing this certificate. We are solving that with working contracts, with renting contracts or a home or whatever. Any document that can show that you have been living at the UK at least for 12 months. There is another requirement that you need to demonstrate that the personal stuff you are carrying is used, is not new stuff. You must give them to the padron registration. I don't know the word in English of the translation of padron. I think there's not that figure there. Is the registration you make in the city you are going to live. The residencia permit, the resident permit, or the application for the resident permit. And I don't know if I am leaving something. No, that's all. And the NIE, the foreigner's identification number here in Spain. With all these documents, you can make an application in front of customs and you can be duty exempt. It doesn't mean that you are custom clearing or paperwork exempt. You must make a custom clearing actually, but you will be duty exempt. If not, you must pay mainly a 21% of VAT. Usually the value of the goods, you must give your used stuff a value. That's difficult because how much does cost a pair of shoes? New, it can cost 100 euros or 150 euros, but how much does cost a used shoe or used shoes? So usually the valuation done to make the clearing at custom is low, but it's completely real that it's necessary to make a custom clearing, and it's completely necessary to pay the custom duty if you don't meet the requirement to apply for the exemption.
Okay. Okay, Richard, I think you had some question for Manuel that you've been, would you like to go on and take advantage now? He's on the panel.
Yeah. Hello, Manuel.
Hello.
We're getting now quite a stream of questions about people who are still trying to buy goods from the UK. Let's name one of them, Amazon, for instance. And they're finding that they're being charged VAT on the goods.
Yes.
And then when they're arriving in Spain, they're being charged IVA, import duty, and an admin charge. Okay, now the import duty and admin charge, I understand. My feeling is that they shouldn't be charged VAT and IVA.
Correct.
Can you comment on that?
Yeah, correct. As an export, here is an import, and is duty. The duty is necessary to pay, but at the UK is an export, and the sellings are exempt, VAT exempt, because they are an export. It can happen that the sellers at the UK are not used or about the export or about the process and are charging VAT, but it's not correct. When you export a good and you have the export document, you need to leave at the UK. The operation is VAT exempt, so you must claim about put out the VAT, the British VAT, not the Spanish IVA or the Spanish VAT is the one you must pay.
If you've already paid VAT, can you get an exemption from IVA? Was the other question. I think the answer is no, but
no. You must ask your seller or your supplier in commercial operation to put out the VAT at the UK. That VAT is not correct. It doesn't apply because of export.
And can you quickly say what the limits are on import before you get import duty or IVA? Are there limits? I mean, if it's less than 50 euros or 20 euros or whatever.
They are going to put out the limit in few months. There are not going to be any limits. But nowadays the limit is 22 euros, very low.
Right. Okay, thank you very much.
Sometimes for courier deliveries with DHL or FedEx or similar companies, people made the registration at the web page of DHL or FedEx or whatever, and it states a low value for goods. They put 20, 30 euros, for example, 20 pounds. And they made the import clearing through a system they have authorized by custom. It's a low value system, and it's quite fast and quite easy to do. That sometimes make people make some trick, is the word in English.
Yes.
And if you must be careful with that, because there are a limit for that. You can state that, continuing with the sample of the shoes, that the shoes that you have paid 50 euros, put in 20 euros. Okay, it's for an individual person in a business. Okay, it can pass. But sometimes people abuse a little bit of that.
Okay, thank you. I don't know if John, do you have any questions for Manuel here now?
Yeah,
from the Brexpats. Yeah,
yeah, definitely. I've definitely got a burning question that keeps coming up, and I think Richard would agree with this. People are now asking a lot about vehicle re-registrations. There's still a lot of UK cars running around on Spanish roads, and naturally so people are starting to panic and looking into vehicle registration. What they want clarifying is, apart from the usual re-registration costs, are there new taxes that they must now pay equally if they're just bringing cars over into Spain?
For cars that are here before the 1st of January, as they were in European territory before of the 1st of January, you don't have a custom work to do. You only must do the registration at traffic authority. You must show that this vehicle, you must prove that in some way. I don't know in what way, because it's quite new all for Alan. I don't know what are going in traffic authority are going to ask to prove that. For vehicles coming in after the 1st of January, if you want make here the registration of traffic authority, you must make, they will ask you about an import declaration. It would be a requirement that traffic is going to ask you about when you are going to make the registration here. Because when you come driving with the car, the custom regulation understand that is under temporary admission. Mm-hmm. But if you want to make the registration because the car is going to stay here, they ask you to make an import. How they evaluate that import? Usually there are tables with the valuation of the vehicles depending on the model and depending on the year of the manufacturing of the car. You must show that tables, and that's the value, the basis value upon what you must apply the custom tax. There is the possibility to ask for an exemption if you feel or you can give the authority the same documents I have explained, because of the moving. If you are moving your residence, the car can be, I think it's up to 2 cars per person. They can be exempt because of moving, as well as the rest of your staff. But if not, if you don't comply the criteria exemption, you must pay the 21% VAT and some custom duty. Yes.
I believe that for those who have already the residencia, obviously, I'm not sure if within the 3 months. I think within the 3 months, and then you register yourself with the padron, is tax-free, Manuel, because you are moving from one place to another. Yes. So I wouldn't find a problem for those who already have in place the residencia. Yeah. But for those who are moving now and coming over, which I don't think will be many because of the lockdown and still haven't been, I guess, cars going through, I agree that will go a new situation, Manuel, isn't it?
Yeah. Right. That's the situation.
Okay, John, anything else? Or we'll jump into immigration question we've got here.
Yep, that's great. Thank you. Thanks for that, Manuel.
Yeah, you're welcome.
Pedro, we've got here a question from immigration, Alexander. If you could please clarify how much per year a couple will need to prove as money in the bank or funds. Could you please say it again? So people are asking how much money. You said 2,100 plus 500, but could you please clarify? And I will always say minimum. And Pedro, could you please turn on the microphone? There we go.
Okay, now can you listen to me?
Yes.
Okay, well, so apologize for the misunderstanding. Probably to Alex. Individually, you have to must show a minimum of 9,000 euros. As a couple, as a marriage, as spouses, is 12,000 euros. So whenever they show an application from a family member of a European Union citizen, they need to show 12,000 euros. Do not be like 12 plus 9. It's just 12 both.
12 during 6 months.
It is not. I think the question is: it is 21,000 euros? No, it's 12,000 euros whenever she applies for.
Minimum and showing money in the bank. Minimum and showing in the bank within 6 months, isn't it, Pedro?
Exactly. Bank statements, we like to show at minimum 6 months, which has an average rate of that money, that 12,000 euros.
Okay, we've got a question. Thank you, Pedro, from Lindsay. She's asking whether we offer tax planning, which obviously the answer is yes. They have 5 privately held rental properties in the UK and a first holiday rental property in Spain, bought by a UK limited company. We currently pay all taxes in the UK, but have just received residencia, so need to move things over. What is the best way to do? Well, I guess, Lindsay, the best thing to do is to do a consultation, private consultation with your specific scenario. You could do it with us and our accountants or with anybody who you wish, and to do a specific tax planning, because yes, once you have residencia, the worldwide income will have to be declared here, except any exceptions that are on the double taxation treaty. So I wonder whether Manuel, Pedro, Richard, and John could put their email in the panel, just in case they want write straight to you in the future. We've got another question from Nikki Thompson. If you own a property in the UK but you don't rent it out, is it tax payable to Spain as a resident? I don't know if Pedro wants to go. UK property, don't rent it out. Is it tax payable to Spain as a resident? Well, you need to declare it here, Nikki, in Spain, in your tax return. Now, to the question, is tax payable? I don't think it will be an input. If you have 2 properties, you'll have to put it to, there is a system that works out a minimum generated income that will show on your income tax return. But probably is not much. But yes, the declaration has to be done here in Spain, correct?
That's right. It needs to be included as an imputación de renta.
Imputación de renta, correcto.
Which probably would be a minimum amount, but it's something that needs to be included.
Right. We move on with Rosalba. We have a property since 2016, but don't have residency. My husband will retire in July. how possible is it to apply for resident for both of us? I guess, again, Pedro, here is another case of non-lucrative visa, isn't it? Or golden visa, or whatever they might apply in the future. Because it's up to 2016, and
that's right.
And if the property
That's
was
right.
worth more over, could you, Pedro, go a little bit on the golden visa just in case applies?
Well, the golden visa, I mean, it's an investment visa. You don't need to be a resident in Spain. You are allowed to work in case you wanted to, but this is an investment visa. Well, the minimum investment is for properties is 500,000 euros. So you invest 500,000 euros in a property in Spain, or different properties in Spain, in different times also. Whenever you show that you have invested totally or minimum 500,000 euros, and at the end you are allowed, in order to enter in Spain, live in Spain if you want to, apply for residency if you wanted to, and basically it allows you to enter in Spain, but also to obligate you to be resident in Spain. It's a automatic visa. It's very fast. It's like in between 10 and 20 days once you comply all the requirements. It's extremely fast. And well, you have to show, of course, the criminal record. You have to show that you have sufficient money to live in Spain, just in case you are not going to work. And you can add, of course, your family members, your spouse, your children. And well, it's a straightforward. And for example, in this case, a specific example, if you bought in 2016, a question could be probably, can I buy something else, adding in order to go to that 500,000 euros and apply for golden visa? The answer is yes. It's after 2013. But probably would be the situation would be for the non-lucrative visa, where it helps just to have a place, a link, in order to show to the Spanish authorities that you have a place to live. And at this time, they are not resident. From 2016, I suppose that they've made the non-resident tax because they own a property in Spain. And well, will be a non-resident visa, a non-lucrative visa, in order to start the process. Of course, we will be happy to inform them and take all the documents regarding that.
Right. Okay. Yes, Richard, over to you.
Yeah, that's a bit of a double-edged question, because it doesn't say that they're not resident in Spain, but they have a residency out here. Now, if they've been resident in Spain and they move quickly, and they can prove they've been resident in Spain, of course, they could come under the withdrawal agreement. And if they like to email me, I'd be happy to talk to them about that. But obviously, it's too complicated here.
Mm-hmm. Richard, do you provide your email address?
Yes, it's in the questions.
Right. Let's move on. I think
I agree with Richard. I mean, probably the intention of the email probably is that maybe they have been residents in Spain. That's correct. Yeah.
Right. I think John had a question because time is running. Over to you, John.
My question was very quick, Pedro. There will be people listening to you talking about the golden visa and the non-lucrative visa. Can you clarify if the golden visa process is carried out entirely in Spain, therefore avoiding that application process via the consulate in the UK?
Well, this could be done in Spain. Could be someone to come to Spain, buy a property, and we apply for the golden visa. That's simple. Also, could be done in the Spanish consulate outside of Spain. So for the golden visa can be in those areas. For the non-lucrative visa, must be done in the Spanish consulate.
Yep. Yep.
And we have right now one of the cases which is a challenge, because I mean at the end the rule is that you need to apply for non-lucrative visa outside. We have a challenge for humanitarian reasons. We can apply it from here, the non-lucrative visa in Spain. Or through a different structure or vehicle on immigration. But this time for the golden visa, we could do it telematically. It's digital certification with the computer, and the golden visa is very, it's very straightforward. Once you comply all the requirements, it's rapid. Non-lucrative visa, the time period for non-lucrative visa, just to have a difference, is, as it was said by Ignacio, when you get authorization for living in Spain for 1 year, plus 2 years, plus 2 years, plus 5 years. With the golden visa, you get a visa. It's not a residency. It's a visa to enter in Spain. In case that you want to apply for residency, you can do that. And what you need to do in order to renew for the golden visa is to maintain the investment. So golden visa, to renew it, 1 year plus 2 years plus 5 years, is to maintain the investment. You need to show whenever you apply for renewal of the visa that you keep the investment. Does this mean that you need to keep the same property always? No, you can sell it and buy another one. You can sell it and invest in a bank deposit, which is 1 million euros. You can sell it and invest in debt, Spanish debt, public Spanish debt. But you need to make an investment. And at the end, you need to show that you have an investment in Spain to maintain the investment. But you don't have to show, for example, that you are resident in Spain. With a non-lucrative visa, in case that you want to renew it, you must show that you've been resident for the period of time that you have been allowed to be resident in Spain. And for the non-lucrative visa, the time is a little bit more, let's say, flexible. Is whenever you apply for non-lucrative visa, the authorities in Spain have 3 months to answer. I would say that in our experience, it takes around 2 months to answer. Once they answer to you, you have 1 month to go to the Spanish consulate and get the visa, which will allow you to enter in Spain for the following, normally it's 90 days. And once you enter in Spain, you will have to apply for an appointment to get the card and make the fingerprints. So all the process may take from the beginning when you apply for until between 3-5 months. And also, of course, without including the time in preparing all the documents before that, which all the documents that are in a different language from Spanish needs to be legalized or apostille de la Haya, apostille of Hague Convention, 1961, and then duly translated, all of them, okay? But this is really the more or less the differences between golden visa and non-lucrative visa. Well, the golden visa, you must invest. With a non-lucrative visa, you don't have to invest, but you need to show sufficient money. As well as for the investment, as for the golden visa, you need to show also that you have sufficient money to live in Spain without working.
Okay, thank you, Pedro. We're running out of time, and we are about to reach 6 o'clock in Spain. Jackie is just saying she's a UK citizen resident in Spain with NI number, TI, social security number. Can I still work in Spain since January 1st? Of course, yes, she can, because she's under the withdrawal agreement and she has not a problem. We've got Mark Mitchell, that is a UK resident, hoping to move to Spain. He purchased a yacht last year near Barcelona, and can I obtain residency to live on the yacht? I'm retired, 49, do not wish to work and have enough funds, 100,000 plus. Yes, I think Pedro, Mark will be able, as long as he could have the padron later on, which we've done it for clients, as long as he's got the money, he doesn't need to live in a property, he needs to have an address, as simple as that, but registration on the padron. We've got Graham Ellis. Basically, I will try to summarize his question. He's basically, Pedro, having problems to, as Richard said, flying over to Spain for the fingerprint. I don't know if Richard or John did experimented something different, but my recommendation is to try to do it as soon as they come, try their best to prove his major force, but I think they could lose the residencia, so they might end up going into an appeal, a resolution, or a problematic situation, isn't it? I don't know if John or Richard wants to comment something about these problems that people not being able to have the fingerprint.
From my perspective, touch wood, we haven't had yet that we know of a case where somebody has actually got back and then not been able to do it. But obviously they're still stuck in the United Kingdom. As far as Richard and I know, and this has come from the UK Embassy, that entry still is restricted to either having the T card or the 𝐜𝐸, the green residencia card or paper. And until anybody gets over here that can physically attempt to do it, it's still very much an unknown. And I don't know whether Richard wants to add to that.
Yeah, I think there are other issues here as well. And it's something that we've got multiple questions on. So I'd like to ask Ignacio and Pedro for their advice. We have many people with children, I use the word children advisedly here, students, stuck in the UK who want to come back to Spain. They do not have residencia and they've got nowhere to live in the UK because the universities are closed, etc. But they can't seem to get back.
But Richard, do the parents have residencia? Do the parents have residencia? So they are dependent on parents, correct?
Well, now here lies the rub.
Below 18 years old, are they?
Here lies the rub. 18, some of them are 21 or 22 years old.
No. My straight answer will be no. After 18, they are not dependent and they need to apply for a visa.
Right, which they won't get at the moment because of the restrictions.
The only thing they could do, if they could ever prove they were resident under the withdrawal agreement in Spain, you know, I don't know whether they were, if they could prove they were here in their income tax return, they were mentioned in their income tax return, padron, certain things, but they never applied. That's why I'm saying in the last webinar, I encourage people, who have enough evidence to prove they were resident in 2020, to try to enforce it now. It will not be a straightforward road. They will probably have to, I'm getting now, Richard, a lot of denied residencias because of the lack of requirements that people in the very last minute, they didn't comply. Well, it's a long process now and a strategy to follow. I don't know if Pedro wants to add something.
Well, it's a difficult situation, but of course, it's difficult to program. But of course, as much as they can show that they were residents here in Spain, living in Spain before they left to study in the UK, and the parents are here, depending economically, and this is easy to show it. Yeah, but it's I agree with you, it's going to be a little bit difficult. What could have been done is just to, before they leave, but of course they didn't know this situation before. It's autorización de regreso. Whenever they leave, they have an authorization to come back. This is what it should be done. So whenever to go to UK in this case, or any other country, to have, before they leave, to have an authorization to apply immigration office. I need an authorization to go back, to have an authorization to come back. But this is without being resident.
Will not be easy.
No, not be easy. No.
I don't know if John wanted to add something. Yeah,
I just wanted to.
We've got just 2 minutes.
I wanted to ask something very specific. We've covered the residency from the perspective of an EU citizen, the Irish passport scenario with a UK joining member. What about the scenario, and this really needs clarifying, for British who have residency, but again are joining a third country national is joining them, for example, from the Ukraine? What if they are both here? One has the residency, the Ukraine citizen, for example, I'm using that as an example only, now needs to do residency, but has gone over the 90-day stay. Where does it stand? Because they want to do the residency.
I didn't get quite your question, John. What is the specific scenario? Just an Ukrainian?
So yes, you've got a Ukrainian citizen, but the UK citizen, this is the opposite. The UK citizen has the residency, but that third country national is stuck in Spain overstaying, but wants their residency. Where do they stand?
We're talking about family.
Family reunification, reunification, marriage, or child.
Yeah, I wouldn't see a problem on that, because the UK citizen has a residency permit under the withdrawal agreement. and then the new one, the non-European country citizen, because of marriage, as long as they're married, very important. And as Pedro said, 12,000 euros within 6 months, proof in the bank. I think they will be able to apply now.
Okay.
Right. I don't know, Manuel, would you like to add some comments about removals? Any advice you would like to make people? Because I know you're dealing with a lot of stress and probably chaos with all these removals, tracks, companies trying to import and export. Would you like to send us some comments on or any recommendation, Manuel?
No, only to be careful which haulia are you contracting, because I am in contact of a lot of hauliers. Some one are big companies, other one are small companies with 2 or 3 lorries making the going out and coming down to Spain and to the UK. And it's important to notice that the haulier is informed that he has the necessary process and the necessary contracts with any custom agent here to deal properly with the removal, because I have found some clients, for example, that has come to me direct, and hauliers weren't informing them properly, because it's quite hard for hauliers to understand all this, especially for UK hauliers. And try to do the paperwork with enough time to avoid paying the tax. I'm very careful with the food stuff. With all the food is quite difficult to import, because they ask about a lot of certificates, and there have been some situation of the custom officers at France asking the drivers to throw to the rabbits their food for their trip, because they can't import. This is an extreme example, but it's necessary to be careful with the haulier, especially we are working with.
Okay, well, thank you, Manuel. I think you left all your details. Richard and John as well, Pedro as well. Just if you need a specific consultation or speak to any of the speakers, panelists, happy to do. We're still having a lot of questions in the Facebook, and I know will be the never ending. We might need to do another webinar at least once a month, probably about all these legal effects. We're going to do different ones as well, because now the main concern, but one piece of advice for you, always try to do planning, because that saves you time and money and stress. I'm going to share with you one video before we go. Juanfran, he could play now with us, and happy to see you either through video conference or whenever you're able to come over to Spain. Juanfran, ¿estás ahí?
Trust is vital when you're in another country. If you want to buy a home, set up business relationships, or apply for a residence permit, you need to be able to count on the best independent legal aid. PELLICER Heredia is an international firm of lawyers with over 20 years experience and one single aim: for you to live at ease in Spain. In order to give you a clear, streamlined and fast response, we work with a cross-disciplinary team of professionals specializing in the main legal fields: civil law, foreigners' affairs, business law, tax and financial law, and international law. And to ensure that you're kept informed and up to date with everything, we have 6 offices on the eastern coast. Whether you're from here or abroad, we will always stand by you and speak your language. Our relationship is based on openness, professionalism, and a commitment to finding legal solutions in your best interests and for your peace of mind. PELLICER Heredia, international lawyers.